Let's quickly do that.
And hello, everyone, and welcome to the Copyright 2.0 show, episode number 377. It is indeed our very first podcast of 2016. I almost said 2015. I have not had to write a check yet, so my brain is not used to the 2016 thing. But as usual, I am Jonathan Bailey from the site Plagiarism Today, which can be found at plagiarismtoday.com. And joining me as usual is the man from D.C. where the hot air blows and the politicians blunder, attorney Evan Sherez, who, as usual, is here to drop all kinds of knowledge and information upon you, but is not dispensing any legal advice today.
Happy New Year, John.
Happy New Year. How you doing?
I'm doing better than Kim.com.
Ooh, well, that's true for about like 90% of the people of the world, of the Western world, I would say.
Yeah, he's not having a great New Year, but I think we all saw that coming.
Yeah.
I had a great holiday. Spent time in Florida, played some tennis with my family. Received my company's first copyright registration that has my name on it, so that was a nice little feather. And
was it a copyright or trademark registration?
Did I say copyright registration? I meant trademark registration.
You said copyright. Of all the people to confuse copyright and trademark, I expect you to be the last.
Well, this was my last show, ladies and gentlemen.
Goodbye, everyone. Evan has been fired. No. It's an easy blunder, because I was talking about copyright registrations, the reason.
I think I was just excited.
He's really excited about this registration. And getting a trademark registration is a pretty big deal in a lot of ways, so it's a lot of work.
It is. It takes a minimum 6 or 7 months.
Yeah.
There's a high likelihood that you're going to get a refusal of some sort, and then there's also a very stressful window where companies that monitor their own trademarks have this window of publication. It's about 5 or 6 weeks where they can either basically oppose your registration by saying that, hey, we have rights in something that is identical or similar. And that basically we passed that, which is a sign that maybe the trademark that we have chosen is in the clear, although now there's always the risk of someone filing for a cancellation. And although it's not real litigation, it's what's known as quasi-litigation, and it could be a lot of work. But it's good. It's, of course, a good sign that we are in the clear. But I could babble on and on about trademark issues.
The Trademark 2.0 show with Evan Sherez and Jonathan Bailey.
I was thinking about suggesting us talking about the Slants case.
Oh yeah,
even though it's not directly.
Yeah. I'm familiar with this actually. Yeah, let's touch on it real fast while we got a minute.
Sure. So basically, there's a part of the Lanham Act, which is the Trademark Act, that governs basically disparaging marks, which is that if I wanted to call my band, the Gingers, and Gingers was a bad term for redheads.
I am really impressed you found the only offensive word that could be said on this podcast.
Well, the reason I said it is that I don't really believe it is an offensive word. I mean,
I know, but point remains. It's a good example.
It's one of the few words that the people who are called it generally don't like it. It identifies that group of people by their appearance, yet it's totally okay. So I did manage to find that. But anyways, this part of the Lanham Act basically tells the government, we don't like this sort of activity. Don't issue registrations if they're disparaging to a minority, etc. There's also another end of that, which is that they don't like to issue registrations for offensive marks, like, fuck you as your trademark. Yeah. But this Asian band called the Slants, and I actually had the luxury of talking with their bassist over Twitter about the decision. They basically were issued a refusal because slants, and that's disparaging towards Asians because of the whole eye thing, and they basically challenged it. They're like, hey, we want to own this word, we want to own this term, and so it should really be our constitutional right to say this and call ourselves this. And the court agreed, saying that the Lanham Act's provision basically discouraged commercial speech, which, although is not entirely protected, is somewhat protected, and that was upheld by the the
Appeals court.
The appeals court, right? The Federal Circuit.
Yep.
And so I think
got you back,
destined-
man.
Thank you. I think it's destined for the Supreme Court. Do you? What do you think about this case, John?
I think it's interesting, and the context everyone's putting it in, understandably, is with the Redskins. Because, as we know, the Redskins had their trademarks. I'm trying to remember the term they used. I'm sure the trademark attorney will help here. Canceled over the disparaging nature of their name. And now we have this ruling, which sort of brings a First Amendment question into the whole issue. Now, obviously, there's some different facts here. There's a big difference between a football team with, I believe, a white owner and, very little to do with the Native Americans, sort of dealing with, using the name Redskins versus an all-Asian band calling themselves the Slants.
Yeah, I don't know if it will end up making a difference. I don't think the court wants to take a position where only a certain group of people can say a word commercially, even though it does make sense ethically to be like, oh, we want to let minorities or whatever disaffected group is use those words that were traditionally used to hurt them and own them. I don't think that you could take that perspective from who's litigating this, and is it constitutional for an Asian person to say slant and in a business, and then unconstitutional for a white person? I don't think they're going to take that angle. I think that the issue remains: can the government come up with an extremely important interest to justify not allowing the registration? And it's just the Federal Court of Appeals did not buy offensiveness as one of those reasons, because if you're suppressing speech, basically, the government needs a compelling, is the term of art, reason to do so.
Yeah. So it's going to be interesting. It's an interesting story, interesting case. I've been following it. It's not my normal wheelhouse, but I've taken a great deal of interest in it. Because I still come at this from a mass media background. That's how I came into copyright. It was via journalism and mass media, so trademark law, obviously, and especially when you're dealing with First Amendment issues of interest.
All right, well,
real fast, before we move on, you know who Tim Minchin, the musician?
Tim Minchin?
Yeah, Minchin is his last name. Tim Minchin. He is a UK musician primarily. He did a song called Prejudice that I think you need to listen to as soon as possible. I'll shoot it over to you via DM real fast here, and that way you can check this out when we get done with our podcast.
Sure.
Because I think you're going to appreciate it in context of the conversation we just had. Second, we get the link. Yeah, it's one of those things that is a little too on point after this conversation. So yeah. Anyways, so first show of the year.
First show of the year.
First show of the year. We are back after a extended time away to celebrate the holidays, celebrate the weekend. We've got a lot of ground to cover this year.
A lot of very cool stories. Why don't you tell our listeners what we're going to be talking about?
Well, first off, we're going to explain why we are both significantly better off than Kim.com right now, even though he is living in his mansion and all that jazz still, obviously. We're also going to take a look at the Copyright Royalty Board and a recent decision that they made and some of the fallout from it with Pandora and SoundCloud. Then we're taking one of my favorite, or one of the stories I'm personally most interested in, Cox and their recent loss of DMCA Safe Harbor and what came of that.
Yeah, great story.
It's a great story. I'm really looking forward to that one. Then we're turning attention to the Hateful Eight and its, shall we say, leak upon the pirate site before its release in movie theaters. And then another story of great personal interest to me as a Star Trek fan. The crowd-funded Star Trek film has been sued by Paramount CBS. I'm not personally very surprised by this. And then we get another Quentin Tarantino story as he is sued over Django Unchained. And finally, a story I'm hoping you can shed a little light on, the Google securing a win over Waze's data database. So this is an interesting episode. Lots to go through. So shall we dive into Kim.com? You know what the U.S. government wants to do?
Sure.
Yeah. Well, the big news, whilst we were gone, because New Zealand court really love wrecking people's Christmases, is that
Yeah.
I know it was a time limit thing. I'm just joking. But yes, Kim.com was ruled to be eligible for extradition. The judge, in his ruling, made it seem like it wasn't even a choice. It wasn't even a contest.
Right. I think he said something like the court had amassed overwhelming amount of evidence against him, and that they, quote, fell well short of undermining the case.
Yeah, I mean, and that's really the crux of it right now is the U.S. government came in, presented the evidence. Kim.com and his attorneys could not provide anything to counter it. And there you go. It's over. Well, no, it's not over because now we got the appeal to this, and then we've got further appeals in the extradition process. So it still could take years for Kim.com to be actually extradited. But this is kind of a tipping point in a lot of ways because now we have a ruling that he can be extradited. Now Kim.com has to find a way to overturn that, and that's the uphill battle.
Right. The case will be appealed. It's basically centered around the Extradition Act of 1999, and I looked at their appeals process, very similar to a U.S. or regular appeals court. Their higher court will basically hear and determine the question of law and figure out if there were any issues with the legal ruling. There's really no new information that can be presented. And in the end, though, they have a number of options. They can either reverse it or confirm it, or even amend the determination of eligibility for extradition, or they could even remit it so that the whole thing would happen all over again, which,
Right.
of course, would be no fun for anybody.
I will go to New Zealand myself and put my foot up people's asses if they go that route. They start this whole process over again. Win or lose, I don't care. You know, what happens at Kim.com, I just don't want it to start over again.
I understand your frustration.
It has been, I mean, let's all put this in perspective. We're coming upon, I think in a few days, the 4th anniversary of his arrest.
Yeah.
And we're just now got our first ruling tending to whether or not he can be extradited. And the court, like I said, seemed very convinced that he could. Not many questions in the court's mind. I mean, it's always amusing to me when the court basically says this wasn't even a hard decision type thing, when they're issuing rulings that are very lopsided like this.
Yeah, I think we have been kind of on point all along when we've talked about he really has no chance.
No.
There's too many big players involved here, and as long as it's a relatively close case, which apparently it was not even close. But I mean, as long as it was a close case, like even if it was maybe a little bit gray, they probably would have done it anyways. But it's so black and white here in favor of the extradition that he really has no shot.
Now, one question that gets asked a lot, including by Kim.com himself, is why is he being extradited to the U.S. when he never set foot in the country? Well, the reason is simple. Many of Mega Upload's servers were here in the U.S., specifically in Eastern Virginia, which, as I pointed out in my article on Plagiarism Today, is a pretty interesting coincidence because, you know, the court that has like the most experience with dealing with this kind of jurisdiction happens to be in the Eastern District of Virginia.
Yeah, not the best call.
Yeah, it's like, okay, picking to host your servers in the U.S., bad call already. But to host them in Eastern Virginia was like double bad, you know?
You know, I think if you look at how they emailed each other and how they ran their lives, it was kind of a Wild West, let's just do it situation.
Yeah.
And obviously they got a little unlucky when it came to where their servers were located.
Yeah, and one thing that was pointed out to me is that maybe, and I believe this is probably true, when they started out, they didn't have the intention of operating like a piracy enterprise. They really did look at it as a cyber locker, storage, file transfer business. But as it grew, they realized that the only way they were going to earn profits was through, you know, turning a blind eye to piracy.
Right.
And it sort of grew from, so they set up and structured the business, including their love for emailing one another all the juicy bits, with a mindset it was a legit company, and only as it went on sort of slid further and further to the dark side.
Well, it looks like he is going to eventually end up in a U.S. court, although one interesting note is that when I was reading the act, it turns out that New Zealand does not allow extradition if the death penalty may be imposed. So he's He's in luck if copyright reform goes in a unique direction.
That would be unheard of. I think the strictest copyright laws I've heard of they're oddly enough in like countries like Romania and so forth, where a single act of plagiarism can get you 5 years in prison. So it can be a bit crazy, and that to me sounds nuts enough. I don't think the death penalty would be an issue in copyright or the actual more extraditable offenses of money laundering and fraud.
Yeah, none of those have the death penalty yet.
None of them carry the death penalty at this time. But if, we suddenly become a totalitarian regime, like that planet on Star Trek The Next Generation where every penalty is death, then the issue's up for debate.
Right. So that leaves us the Copyright Royalty Board story.
Yeah, this one is fascinating. The Copyright Royalty Board, for those who don't know, is basically akin to a court. It is run by 3 judges, so they get to set the royalties for the statutory licenses under copyright law. And these rates have a huge impact on services like Pandora that take advantage of those statutory licenses. And these are licenses, by the way, that you are compelled, that you're basically forced to agree to. This is under the law. So,
right.
You get to say no. Basically, the court's saying as long as Pandora agrees to pay this for a service that doesn't allow users to select the tracks, because services like Spotify and all that are not covered underneath this.
Right. These rates apply only to sound recordings played on non-interactive webcasts.
Yes. And so they come back I think it's every 3 years, correct? I'm trying to remember. They come back every 3 years or so, and they
it's not 5?
It might be 5. But yeah, they come in and they check out the rates.
Yeah, I think it's 5 years.
Okay, it's 5 years. Okay, you're right. It is 5. You're right. I don't know why I said 3. It's interesting.
You're off the show, John.
No, now it's my turn. No. Oh, God, now there's no podcast. But yeah, basically they set the royalties that Pandora and others will have to pay for the sound recordings. And in this case, they actually they had their little powwow. They listened to the sides and they agreed to a slight increase for free listeners. It bumped it up, not a very significant amount. I think it took it up from 14 cents per 100 plays for a song. So if you basically play a song 100 times on Pandora, they are currently making 14 cents. Under the new rate, they will make 17 cents.
Right, and it doesn't seem like a big deal, but it is a big deal because playlists on digital radio tend to be diverse and inclusive of a lot more independent artists, and it's not just Katy Perry and Justin Bieber like you're hearing on the radio. It doesn't necessarily mean that these independent artists are now going to make big bucks, but for a lot of independent artists, these are significant chunks of their overall revenue. So an increase for them matters.
Now, what's interesting is for paid viewers, so if you pay the little bit extra and subscribe to that Pro Pandora account or whatever, Pandora 1 is what they call it, sorry, it actually goes down a little bit because currently it's 25 cents per 100 plays. Under the new plan, it will be 22 cents per 100 plays. But the problem is free listeners make up by far the lion's share of the audience. So I
agree.
The increase is much, much greater than the decrease, basically. And even with the decrease, obviously paid listeners are still more valuable than free ones to artists as well. So I find it interesting they decided to decrease the paid rates, but increase the free ones. But, maybe they're trying to encourage Pandora and others to shuffle more of their customers over to paid plans.
And well, I think I did a little bit more research on this issue, and I do think it's important that we give a second of airtime to basically small commercial webcasters because they may face new challenges under this system. The previous system offered them multiple options for how to pay digital performance royalties for sound recordings. So if your annual gross revenue is under 1.25 million, you could either pay the per performance rate or pay a percentage of your revenue and expenses. So not every small broadcaster is basically saved with this small webcaster tier. And basically, there's this $500 minimum. Sorry, my notes got
It's all right.
Right. So basically, what it ended up saying is that small webcasters that were already paying at a performance rate will find their fees going up.
Yeah.
So that was basically the message of it.
Yeah, and it's worth noting those small ones are the most vulnerable. Because the Pandoras and so forth, yeah, Pandora struggled with profitability, but the company itself is not in any jeopardy, really.
Right.
I mean, iHeartMedia and the other big players, they're not going anywhere with this increase. Yeah, it means, slightly smaller profit margins, or maybe they're going to have to figure out ways to bring in more revenue to find profitability. But those smaller players, they really could be put out of business by any increase, because this is a very low margin business at the end of the day.
Right.
So there's definitely some concern there. And a lot of the concern about the profit margins comes from the fact that services like Pandora have been encouraging and largely leaning on free users. So part of what the Copyright Royalty Board seems to be trying to do here, like I said, is push these providers into getting more of their customers to pay premium plans, for higher royalties, but also since now the increase, because previously, like I said, the increase in what you had to pay for the on these particular royalties, at least, went from 14 cents to 25 cents. It damn near doubled. Now you would jump up from 17 cents to 22 cents. That's a much smaller bump up in the royalties from free to paid. So it seems to be an effort to encourage these broadcasters to try and encourage more customers to sign up for paid services rather than simply just accepting free as the status quo.
Good point, John.
So that there was some very, very quick fallout from that as other royalties began to get settled at about the same time.
We have a skew of settlements here to report.
Yes, a pair of them specifically. The first is Pandora. Again, and their settlement with ASCAP and BMI. Now, ASCAP and BMI represent where the Copyright Royalty Board dealt with the sound recordings. These deal with the compositions. And remember, with every song, there's two copyrights. There's the right in the composition, and then there's the right in the actual sound recording. You got to keep them separate. So here we have Pandora ending its quote-unquote battle with ASCAP and BMI and agreeing to a new rate. And basically, what happened here is this is a very similar situation where there's royalty rate courts, but it's a different set of rate courts. It's not the Copyright Royalty Board. It's an actual rate court set in by a consent decree. Because that's how you know the government thinks you're a monopoly. Not only do they put a consent decree on you, they give you a special court to lord over you.
Yep.
Well, which is exactly what happened.
The two parties ended their litigation. They sent out a joint statement stating that the deal allows both ASCAP and BMI to further their goal of delivering improved performance royalties for their songwriters and publishers, while Pandora will benefit from greater rate certainty and the ability to add new flexibility to the company's product offering over time.
Now, personally, even though these are different royalties, I don't think the fact that this was announced a few days after the Copyright Royalty Board is a coincidence.
Right. It allowed a company like Pandora to get a, I guess, more concrete grip over their bottom line over the next 5 to 10 years.
Yes.
Specifically 5. And then at that point, we're able to make the calculation as to whether settling was in their best financial interests with kind of the other puzzle piece in place.
Yeah, and it also let ASCAP and BMI know which way the winds were blowing when it came to whether royalties were going up, down, sideways, or whatever.
Right, because while royalties went up, they did not go up as much as
many expected or hoped. Yeah, and that's exactly it. So basically, with that Copyright Royalty Board ruling, it sort of set I'm going to say some ground rules here that a settlement could be reached with ASCAP and BMI. And this basically means for Pandora, they seem to have all of the royalties they have to worry about locked in at a rate they're comfortable with for some time into the future.
Yeah, it seems so. Unlike, of course, our next story, the SoundCloud deal, which was a little funny. It seems they have are you ready for this? Multi-month deal in place.
Sorry.
What a way to spin a short-term survival deal.
Multi-month. I love that. I must have misread that. That is beautiful, though.
Yeah, very odd. They basically...
I am a connoisseur of BS, and let me tell you, mwah, that is some beautiful BS.
Yeah, SoundCloud was at war with a British agency similar to BMI called PRS. And, of course, SoundCloud, is another one of these audio lockers. I've used it for my own band, where you can upload music and have other people listen to it. And, of course, with that service comes the problem of piracy. And the British group PRS, which stands for, give me a second, PRS, Digital Music.
Yeah, multi-month deal. I'm sorry, that's gonna linger for a bit, like a fine wine.
So I'm searching for this. I thought I had this in my notes. Do you know what PRS stands for?
I know it does stand for something, but no, I do not off the top of my head.
Yeah, even their music, they only like to use their initials. Anyways, it's not really important. They have this deal in place with SoundCloud. It's obviously a let's see how this works deal. That's why it's only a few months long.
Okay, it's the Performing Rights Society.
Performing Rights Society. If I was asked to guess, I probably could have guessed that.
Yeah, you could have just yelled Yahtzee on that one and gone for it. Yeah.
Right. So SoundCloud, unfortunately, still has ongoing litigation with a number of other rights-holding groups, including, from reading here, UMG, which is Universal Music.
Yeah, and Sony Entertainment.
So they're not quite out of the woods yet.
Yeah, they are still fighting this. And it's very interesting because the big comparison SoundCloud gets is that it's like YouTube. Because in many ways it is. It's YouTube for audio. I actually looked at it at one point as a podcast host, but it's just not structured very well for a podcast host. At least not in my opinion. But the long and short of it is, much like YouTube had some serious copyright issues in its early days that it sort of had to address and correct, it seems SoundCloud does. But it looks like, judging from these licensing deals, SoundCloud is having more struggles than YouTube did, partly because YouTube got bought out by Google very early on, and Google just has the resources to throw at solving these problems.
Yeah.
There's an advantage there.
I think that brings us to my favorite story of the day.
Yes, this is the one we've all been looking forward to. Rights Corps, well, technically not Rights Corps, it's BMG Rights Management, but Rights Corps is their copyright enforcement agent.
Division, yeah.
And Cox, which is the ISP I am on, I should add. So, yeah, outline this case for us.
Right. So we've talked about this
a few times.
We talked about this last, is it not last episode?
It might have been last episode, yeah. We've had the break, yeah.
Well, Cox is an ISP, as in they provide internet access to individuals in their area, you being one of them. And they basically suffered a very important landmark defeat. And that defeat, I think, was set in stone 2 weeks ago when a judge issued a summary judgment against them saying that they did not have they were not entitled to the DMCA's protection for a copyright infringement related issues. One of the key issues in retaining this protection is a meaningful repeat infringer policy. So as an ISP, you have to have some sort of meaningful policy which terminates permanently individuals who are using your service to flagrantly infringe on copyrights. So this court basically looked at their policy and they said, okay, let's first talk about what is a meaningful repeat infringement policy. And they said, basically, at a minimum, instances where a service provider is given sufficient evidence to create actual knowledge of blatant repeat infringement by particular users, particularly infringement of a willful and commercial nature. When this happens, you have to basically do something about it. You have to have a policy for these people. And BMG basically argued that, hey, there was no policy. And the court basically looked at the facts and they were like, you know what, you're right. Not only was there nothing before 2012, but afterwards it was a bad policy. They had number of examples to use here, and I took one of them out. In one email exchange between representatives of Cox, someone reached out to their superior and said, here's another example of a customer that I consider a habitual abuser. What should I do? He's been terminated twice in a single year. This was one of the main issues, is that while they would terminate people, they would just let them back on. Oh, we've canceled your service. Hi, sir. Would you like some service? That doesn't count. Basically, in response to the previous quote, the boss, Mr. Zabek, stated, it is fine. We need the customers. So when that sort of evidence comes before a court, what do you think they're going to do? They're going to say, okay, you had no repeat infringer policy, which means that you no longer are eligible for safe harbor under the DMCA. And then when your users are, trafficking in a number of infringing material, you're going to end up liable.
Yeah. And basically, that's what that safe harbor is there for, is to keep you safe when your users, as they're wanting to do on an ISP, infringe other people's copyright, either through BitTorrent or whatever.
Right. Something there's just nothing you could do if you're a third-party service. You're an ISP. Every ISP has users that are going to infringe copyright. It's just the nature of the beast. But you have to have some sort of meaningful policy, and you can't just let your worst users back on because, quote, you need the customers.
Yeah, and it goes back to the great expression, say it, forget it, write it, regret it. They wrote it, and now they regret it. And the result of losing that safe harbor was basically this case went to what was, I think it was effectively a damages-only trial. But when the judge had ruled on safe harbor, that left pretty much no issue of,
Right. There was still you had to show that somebody owned a copyright, and that's infringed, it. Which was really only a trial on paper.
Yeah, that was pretty obvious.
Yeah, that was not disputable.
The big question was, how much is Cox liable for? And the jury has come back and said $25 million.
That's a lot of money.
I mean, it's not going to bankrupt Cox. It's not going to, end the company. It's not going to end them. But it's an amount with some sting.
It's a good, solid amount of money.
And I'm not referring to the professional wrestler sting either. It's just good old fashioned actual sting.
Right. It also sets an interesting precedent because of the way Rights Corp was going about sending their notices. So, and this is one of the issues of trial, is that when they were sending notices about infringing material, they would say, please take this down or just send me $25. So it was this very strange settlement offer in every notice.
Yeah.
And so Cox was like, okay, this is clearly a business model. This is phishing This is a phishing technique. This is the sort of thing that's frowned upon. They're not going to get away with this. Well, it turns out they did.
Yeah. And that's one of the things that I think the real outcome of this is not that, Cox will necessarily pay $25 million. It's more an issue of this will embolden Rights Corp, because they will have a big win under their belt as they approach other ISPs, but also it raises some interesting questions for the six strike system in the U.S. A, the six strike system is coming up for review soon, and B, Cox was probably the largest ISP in the country not a part of that system. And I guess they still are not part of the system. But yeah, basically that's the system where now there's a cooperative effort between at least the large rights holders and the major ISPs to sort of pass along these DMCA notices, pass along warnings, and take a selected action. Now, under the copyright alert system, account termination is not actually part of the process. So this means that ISPs, even those that are part of the copyright alert system, may need to think about account termination and the repeat infringer policy. Well, no may about it. They do need to.
I think they do as well.
So there's no may there, to be honest.
But with a grain of salt, that's only from a litigation perspective. You know, if you're a part of a roundtable best practices group and you meet up and you find like, okay, this is what works for us. Do you really need to have a termination policy? I don't know. How much do you trust the guy across the table from you? I don't think these big players are seeking to gotcha litigation kind of.
Well, it's not the big players I'm worried about.
Right.
It's the smaller guys that I'm worried about now.
Right. It's honestly whoever's in Rights Corp's
stable now.
Target, whoever's under their scope. That's the word I'm looking for. Whoever they're looking at, you need to be worried because they're really the only major player doing this gotcha litigation and work and really succeeding at it.
No. And like I said, this is a pretty big blow for Cox. Now, I have no doubt there will be an appeal. I have no doubt there will be further steps taken here. But still, at the end of the day, I expect that the lack of repeat infringer policy is pretty clear. So if we're going to agree ISPs need that, Cox's situation isn't going to look much better.
Yep.
So yeah. Go ahead.
Nothing. I was going to move on to the next story and.
Yeah, have you seen The Hateful Eight?
I have not.
I have not. I've heard very mixed things about it. But a lot of my friends seem to really, really love it. However, The Hateful Eight made, shall we say, an unscheduled appearance on various pirate websites as apparently an Oscar screener wound up in the hands of some people who, were not ethical about it. And long story short, it eventually leaked its way online days before its release in theaters, almost a week before its release in theaters.
Right, it had something like 600,000 tracked views, so that's a huge a piece of money for Quentin Tarantino. It doesn't necessarily mean that every single one of those people is going to pay for his movie, but
even if only like a small percent would have, it's still a potentially huge hit.
I thought Quentin Tarantino was one of those guys who had so much credibility as an awesome artist that he never went and did the studio movie that everyone would want to make him. That people would be that this was the one guy who, if his stuff was hacked, people would be like, no, I want to see this in theater because we love Quentin Tarantino. He's cool. We want to reward him for making cool movies. But. Yeah. Obviously not.
Yeah, obviously not. The movie does appear to have suffered at least some, though it also probably suffered some from the fact that it was still going up against the new Star Wars release.
Right, which has already become the most successful movie of all time.
Yeah, I think so, yeah.
You've seen it?
No, I've not seen it, actually.
Oh, okay.
I actually saw Krampus rather than the new Star Wars movie.
Are you going to see it?
I am going to see it at some point. I just don't know when. It's not a super high priority because I've apparently avoided the spoilers pretty well, so now I can kind of relax and see it whenever I've got the extra time.
All right, well, I know that my expectations were extremely high going into it, and maybe that affected my film-going experience, but I'm going to say this. I didn't think it was that good.
You didn't? Okay.
I didn't. So
you are the first person I've spoken to who has said that. I'll be honest with you. I'm surprised, but it's an opinion that I can take into consideration because I know I tend to align with your view on film.
I thought it lacked a little bit of depth, but the dollars obviously say otherwise.
Let me ask a question. Are you Star Trek or Star Wars?
I was probably Star Trek,
Okay.
which maybe colors, my sci-fi preferences. I like real deep sci-fi rather than just pew 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 pew.
And that's fair. And I'm a Star Trek guy too. I grew up with it. It was my it was my sci-fi. I have an appreciation for Star Wars, but I was definitely more of the Star Trek guy. I especially the Next Generation. In the Kirk versus Picard debate, if you're more of in the Kirk camp, I don't understand you.
I'm a Picard guy too.
Yeah, it's Picard, man. I'm all about the diplomat who also can kick ass, rather than the guy whose only solution is to punch an alien in the face.
Right. My dad loves that. There are four lights. That's his favorite quotes of all time. But anyways, I think this is one of the best segues we've ever had. Let's talk about Axanar.
Yeah, Axanar is... Okay, the Axanar is a tough film to explain if you're not a Star Trek guy. But basically, in the original series, Kirk talks about one of his idols from basically, I think it's like a century before, but basically it was a guy who goes by the name of Garth of Izar, who was a great captain, great military commander, and helped win a crucial war against the Klingons. And basically, if I recall correctly in the episode, because I've seen all the original series, but a lot of it didn't stick. You know what I mean? It's not like the Next Generation where I can quote like half the episodes.
Yeah, it is a little bit before our time, so it takes
them. But they actually meet, and Garth of Izar basically turns out to be a giant, douche nozzle and a terrible human being. Well, this movie, Axanar, would look back at the war Garth of Izar fought in. The only problem is, it was not an official Paramount or CBS film. Instead, it was a fan film funded on Kickstarter, oddly enough.
Right, and it was funded quite well.
Very well. More than $1 million was raised for what they said was a quote-unquote professional quality Star Trek film.
Interesting choice of words. I think depending on your copyright or copyleft stance, the word, it's a fan film. That's one way to put it. Another way to put it is it's an unauthorized, completely, unagreed to infringement. There's two ways to look at it.
Exactly.
I don't know what to think about this one. The creator was evidently told by CBS that the film, couldn't make money. He had a meeting with them. He wanted to do it the legit way, and they said, this film can't make money. We don't want to do it. And he took that as a sign that, they'll tolerate the film because if in their opinion, the movie won't make money, it is therefore not a commercial enterprise, and it is therefore fair use.
Enterprise. Haha.
Got that, eh?
Not bad, not bad. I respect that.
Yeah, so they took that, and they took this fair use leap that many people tend to take, that, if it's not going to be commercially successful, or if it's not intended as a commercial or as a money-making venture, it is therefore under the fair use umbrella automatically. That is an error. That is not the case.
No. And here's the thing. Paramount and others, nearly all major content creators, I find, are fairly tolerant of truly fan creations.
Right.
Otherwise, DeviantArt would be like, DMCA Central. You know what I mean? It would be atrocious. But yeah, they're pretty tolerant in general. And there was a time and I recall this, because back in like the GeoCities era of the web, might be before your time, Evan.
I remember GeoCities.
I actually tried to create a Star Trek fan site for the next TNG. And I ran into some trouble because, Paramount was not really dealing with the internet very well at that time. And so what they did is they basically said, if you want to create a fan site, here's your fan site kit. You can't use anything not in this. And they had a bunch of stock images and logos and things, and you had to sign an agreement to use it. And I just said it was too much trouble, and I walked away from the project. I wasn't committed enough. But they've changed attitude a lot since then, and now there's whole like fan fiction forums. There's these large communities that go around and swap both artwork and stories and other unofficial Star Trek stuff.
Yeah. That's
totally with their
tolerable
blessing.
stuff. That's, in my opinion, of course, that should be allowed. But the pragmatic traits and the promoted traits of this film are what does it in. They were like, we want to make a high quality, big production, real film, and we're going to get actors who have played the parts in the past. We're going to get Richard Hatch and Tony Todd and Kate Vernon and big names, and Gary Graham, who was played a Vulcan ambassador.
Even George Takei was involved.
Yeah, so you can't take all this together and then open a $1 million Kickstarter and then not expect to have to license it. And if you don't get the license, I'm sorry, you don't get the license. There's nothing you could do about it, because this level of a production will attract the attention that it has attracted, which is from the copyright owners. And unfortunately, I think that unless they get a license, they're not going to be able to produce this film.
No, I agree. And it's interesting because one of the questions probably one of the most common questions I get, because this is also true, the second most popular post on plagiarism today, out of the thousands of posts I have up there, the second most popular post is entitled "The Messy World of Fan Art and Copyright," talking about fan art and fan fiction and where it intersects with copyright law. And the most common question I get is this type of fan fiction, is this type of fan art okay? And it's always such a thorny question because, the boundaries are murky enough when you're dealing with derivative works and fair use, but then you throw in sort of the weird permission system of fan art and fan fiction. And now you have this grenade thrown in where someone really tried to take the football and run with it. And this basically has apparently been spiked on the 1 yard line pretty hard.
Yeah. Although I do have to say, I am at the Action R website right now. Their animation is pretty impressive.
Yes, it is. I have seen the preview they did, and they are really, really impressive with what they've done. And I was really stoked about the film, but I'm like, I don't think I'm ever actually going to watch this film. Because, I contributed to the Mystery Science Theater 3000 Kickstarter that they did to bring that back.
I've been hearing about that quite often. That's gaining a lot of steam.
I'm silly stoked about that. But that being said, that's got the actual rights holders behind it. I saw this, I'm like, ooh, I should contribute to... Wait a minute, I'm never going to see this film, am I?
No, I don't think so.
I'm not.
They need a license. And, I don't know why CBS would reserve its licensing. Maybe they just don't want it to be really bad. I don't know, because they are coming up with a new Star Trek series.
Yes.
And there's a new Star Trek movie coming out. So maybe the money wasn't there for them. Who knows? We'll have to keep an eye on this one, and hopefully it gets sorted out and the license is granted.
Yeah, but when it comes to this type of fan fiction, and another example that this actually did come up, was a guy who had been really good with Star Wars fan fiction. Was really popular in all the forums, had a name, had a reputation, decided to start selling his books on Amazon through self-publish, one of those self-publication things. And yeah, guess what happened? Just take a guess. It's not pretty. There's a line you can't cross it with fan fiction and fan art, and that's what Action R seems to have done.
It absolutely has. It's gone way over the line.
It's gone way over the line. It's in another zip code now.
Yeah, well, I encourage our listeners to go to www.axanarproductions.com. Take a look for yourself. The list of actors and the, I guess, really high quality of it. It looks like a real movie, and that's the level that you need to get licensed. I think that brings us to this next story, which is another funny one. The Django Unchained.
Yeah, speaking of no chance.
Tarantino. Speaking of no chance, Django Unchained is being sued
for $100 million.
$100 million, right?
By
So, ladies and gentlemen, here's a quick lesson on copyright 101.
Yeah,
you cannot own the concept of a film. You cannot own a spy. You can own a character called James Bond. However, you cannot own a British spy who is suave. Those are not ownable, copyrightable concepts. So if you're suing Quentin Tarantino because, quote, before Django Freeman, there was an escaped slave named Jackson Freeman who desired, Freeman, not exactly an original name, who desired to purchase his family's freedom from a malevolent plantation owner.
Like there were good slave-owning plantation.
The suit filed in federal court in Washington, D.C. reads, before Dr. Schultz, there was Samson, another white man who would assist Mr. Freeman in his efforts to rescue his loved ones from slavery. So you pause for a second, and maybe for a slight second you're like, those are kind of similar. But then you're like, wait, there was this thing called history where this happened all the time.
Yes.
There was millions of black people enslaved, and then after the Civil War happened at some point, or before the Civil War, some white people tried to help them rescue their families. These were historical facts. So you can't say that this is somehow original, copyrightable storylines when they're all based in the experience of Americans in the 19th century as this country was ending the plague that was slavery.
Yeah. And even if you can, then you have to show access. You have to show that somehow Tarantino ran across this original screenplay, and their case there is equally thin.
Right. So beyond the copyrightability issue, which is one. Then there's the access issue. Then there's the thinness or thickness of the copyright. Sure, your story is somewhat original enough to be copyrighted, then okay, how thick is that copyright? Or is it a very thin copyright in which it must be copied verbatim in order for there to be an infringement? Well, I think in this case it would be an extremely thin copyright because it's based in, like I mentioned, based in history, and it's based in a story that's been told and retold many times.
Yeah. It's just there's no chance here. I would be willing to make one of your streak naked through the streets of New Orleans types bets on this one.
I wouldn't blame you. I don't think this one has a chance.
Not a chance. I think a snowball might actually have a greater chance in hell.
All right. Well, that brings us to the last story.
Waze and Google. This story fascinated me a little bit, and I think it's an interesting story from a copyright standpoint because Google basically purchased a mapping service called Waze. And Waze, have you ever used Waze?
I have used Waze.
And Waze I think it's pretty cool, actually. I do use it a lot when I'm trying to deal with traffic. It's a great GPS. But apparently, the accusation here was that Waze copied some of its data from a points of interest database owned by a company called Phantom Alert. That's the only correct way I think you can say that name.
Yes.
The alert is all caps, so it's Phantom Alert is the name. But yeah, and to prove this, Phantom Alert showed that Waze had points of interest in its database that were false entries that they had put into theirs, so-called, Easter eggs.
So exactly like Vice versus Rural Telephone Service, which is the 1991 Supreme Court case in which one party put fake phone numbers into their phone book to see if a rival was stealing their phone book data.
Yep.
In that case, although they caught them the
dirty bastards
stealing the phone book, stealing the information that was in the phone book. That's not creative information. That's just information.
Yes.
You cannot copyright the numbers in the phone book listed alphabetically
because there has to be a requisite level of creativity, and it turns out A, B, C, D, E, F, G doesn't qualify.
Exactly.
Basically is what it comes down to. And long and short of it is that the court had a very similar holding here, held that the Phantom Alert's database is factual selections, not arranged in a creative manner. And even though they might have some kind of copyright over the database as a whole, over the individual entrants, no.
Right. The court basically said that there is no originality in how Phantom Alert organized these points of interest. Therefore they had no case in copyright law. Case closed.
Yeah. Yeah, long and short of it, that's the end of it. And it sounds brutal because there used to be a time in U.S. copyright law where the sweat of the brow, was the actual term used, would give you some degree of copyrightability. If you gathered this and compiled this at some great expense or great labor, you could have some hold. But no, modern copyright, it's all centered around this idea of creativity. And Feist actually was and it's kind of odd for us to think about it, but yeah, Feist was a 1991 Supreme Court decision. It's like, phone books were around in 1991? Yes, they were. There also wasn't much internet in 1991. That's how fast this crap took off.
I haven't seen a phone book in 5 years.
I think I might have one in my office. I think it's propping something up. I still get them on my doorstep every so often, and it blows my mind.
Well, yeah, no, it's fascinating how the non-technological past can remain excellent precedent, and you can translate some of the lessons, right into the internet age.
Yep, because basically that's what it is. If you think about it, that's what it is. A phone book is a database in print.
And the Waze app is a database of traffic information.
Exactly, and points of interest and other information. So, yeah, and it translates almost perfectly. It's creepy almost. In fact, I would not be surprised. I know, obviously, the judge was going to cite, but it would have been very trivial just to plagiarize the Feist ruling in many ways.
Take some sentences from that ruling. That would have been a little bit meta over there. Well, I know you got to get going, John.
I do, but it's been great chatting with you, and I think we've got a great episode here. I had a good time talking about this and catching up. It's been interesting. And do you have any, real fast before we go, do you have any expectations or predictions for 2016?
Do they have to be copyright related?
No, they don't have to be. I'll take anything I can get right now.
Okay, I'm going to predict that in 2016, we will make contact with an alien species.
Ooh, alien species, that'd be nice. Well, if we're going to make outrageous and outlandish predictions, I predict in 2016 we'll make sense of copyright law. I think yours is more like...
I thought you were going to say the Cubs were going to win the World Series.
No, I think that's less outlandish than making sense of copyright law. I think both contacting an alien race and Cubs winning in the same year has a better shot.
That's a sign of the apocalypse to come, though.
Yeah, if we actually make sense of copyright law, we will just give it up. It's time for humanity to end. It is over. We've achieved all we can achieve. Well, it's great chatting with you.
Great chatting with you as well.
Well, as usual, I am Jonathan Bailey from the website Plagiarism Today, which can be found at plagiarismtoday.com, and I am username Plagiarism Today at all the places.
I'm Evan Cheris. Find me on Twitter at Evan Cheris. Shoot me an email.
And it's EVANSHERES, Cheris.
Right.
All right.
Or you can shoot me an email at esheris@gmail.com.
Same spelling. Well, on that note, everyone, thank you very much for joining us, and we will see you guys next week. Happy New Year, everyone.
Happy New Year.